We're live. We are talking about joinder, starting on page 13. The absentee or available parties. 2, the extent to which such prejudice can be reduced or avoided by shaping relief. And 3, adequacy of a judgment rendered without the absent party. And 4, whether the party will have an adequate remedy in another forum to determine if the case is dismissed for non-joinder. Right? That's your indispensable parties analysis, clearly cut off somewhere on page 12. Permissible joinder. In California, plaintiffs may join together if 1, they are asserting a right to relief arising out of the same transaction occurrence or series of occurrences, and a common question of law of fact will arise, or 2, they have a claim adverse to the defendant. Similar requirements apply to the permissive joinder of defendants. Joinder of claims, Part F. A plaintiff can join any number and type of claims against a defendant when multiple plaintiffs or multiple defendants are involved. It is essential only that one common question of law or fact must be present. This broad rule is limited only when there are several defendants in the action. In that case, there must be at least one question of law or fact common to all. Additionally, the court has discretion to order separate trials if unfair prejudice or delay would result from joinder. Class actions to California state courts. In California state courts, per statute, a class action may be maintained when the question is one of a common or general interest of many persons, or when the parties are numerous and it is impracticable to bring them all to court. Before the court, the minimum requirements for certification of a class are 1, an ascertainable class, 2, a well-defined community of interest among the class members. Opting out. Any class member who does not opt out of the class action after receiving proper notice of the opt-out right will be bound by the judgment. Notice. California permits notice by publication in some instances. In California, the court also may impose a cost of notice in either party. Federal procedure requires the cost to be borne by the plaintiff. Aggregation of claims. In California, the class members' claims are aggregated to satisfy the amount of controversy required for California subject matter jurisdiction, settlement, and dismissal of claims. The requirements for approval and notice to class members of settlement are similar to the federal rules. Representative suits, a person or entity sues on behalf of real properties and interests. Representative suits are not always subject to the same strict requirements as those governing class actions. For example, the representative is not necessarily required to have an injury in fact that is typical to the group of he represents. Common types of representative suits are those brought by taxpayers, shareholders, homeowners associations, etc. Interpleader. California's interpleader proceedings are similar to those under the federal rule and statute, except that it is unclear under California law whether the stakeholder needs to be a disinterested party. Nature. An interpleader suit is instituted by a person in the position of a stakeholder to require the adverse claimants to determine which has the valid claim to take to the stake. It applies if separate actions might result in double liability against the stakeholder. Intervention may be granted to a party of right or permissibly. Intervention of right is available whenever the applicant claims an interest in property or transaction that is the subject matter of the action, and the disposition of the action without him may impair his ability to protect the interest. Permissive intervention is available when the applicant's claim or defense and the main action have a question of fact or law in common. No direct personal or pecuniary interest is required. In California, the principal issue that arises in permissive intervention is whether the potential intervener's interest is direct and immediate, which is required for permissive intervention, or is indirect and consequential, which would defeat intervention. That's a little different. Which it says is different. So intervention Permissive intervention is available when the applicant's claim or defense and the main action have a common factor law, no direct or pecuniary interest involved. In California, the principal issue that arises in permissive intervention is whether the potential intervener's interest is direct and immediate, which is required for permissive, or is indirect and consequential, which would deviate intervention, permissive intervention. So this is a requirement then for permissive intervention. All right, so an intervention of right is available whenever the applicant claims an interest. Highlight this in another color. Intervention of a right is available whenever there's an interest has what? Applicant claims an interest in the property or transaction that is the subject of the suit, right? Third party practice. Impleader. A defending party may implead a non-party who is or may be liable to him for any part of a judgment that the plaintiff may recover against him. Example, claims based on indemnity. The cause of action in a permissive cross complaint adding a new party for any purpose, not only indemnity, must either arise out of the same transaction or occurrence as the original plaintiff's cause of action. Against a third-party plaintiff, or it must assert a claim or interest in the subject of the plaintiff's action against the third-party plaintiff. Third-party plaintiff may then join any other new third-party defendant if it would not violate California's liberal joinder statutes, and may join any other cause of action he has against any of the third-party defendants. In addition to filing an answer to the cross-complaint, the third-party defendant may file a special answer asserting any affirmative defenses against the original plaintiff that the third-party plaintiff has. Cross claims. Co-parties may assert claims against each other that arise out of the same transaction or occurrence as a main action by filing cross complaints. In California state courts, a cross complaint against a co-defendant is permissive, requiring a transactional relationship to the original complainant or claim an interest in the subject in the original complaint. So we move on to the next section, which is discovery. Duty of disclosure. Unlike in federal courts, there is no automatic disclosure requirements in California state courts. The scope of disclosure and discovery in general, the California standard is broader than in the federal. Rules of civil procedure, the information must be relevant to the subject matter involved in the pending action. So, if the scope of discovery in the federal rules of civil procedure is any non-privileged information that is potential to reveal relevant evidence relating to a claim or defense, I believe. And so here they're saying inversely, or not inversely, but in a broader sense, relevant. The scope of discovery is relevant to the subject matter involved in the pending action. Then what happens? Then I believe we just skipped some pages again. Oh my God. We skipped page 15 and 16. Reason why is those are on the wall. So let me just look at my outline to see if I have what comes within discovery. I didn't think discovery was very important. Initial required disclosures. Any non-privileged matter relevant to a party's claim or defense, or that could identify relevant matter. Okay, so that's how it's different, whatever. Required initial disclosures, supplementing initial disclosures. In California, parties have to motion for this. The scope of disclosure and discovery, relevant non-privileged matter reasonably lead to discovery of relevant matter. Relevance, work product protection, non-product petition to protect evidence in anticipation of an appeal is a special motion in California. Work product protection. What am I trying to say here? Product of mental impression of lawyer or trial preparation material not discoverable in California, only available on a showing of substantial need in obtaining in an alternate way, unless resulting in injustice. Okay, so I've also written here, I don't believe that that's true in California. I believe that's the case in the Federal Rules of Civil Procedure, but not in California, right? Is that there's going to be work product is just like protected. There isn't like a substantial need, and the information can't be obtained in any alternate way. Unless resulting in injustice. What does this say? So then you've got other privileges, specific statutory definition of privileges. There, within privileges, there's a California right to privacy, which is probably wholly different from the Federal Rules of Civil Procedure. Somewhere within California right to privacy and protective orders, I have like a lot of notes. So the petition to protect evidence, right, in anticipation of appeal, 235.050, is a supplementary disclosure and discovery response, right? But again, back to this protective orders thing, I think this is where it's coming from, is that there's a legitimate privacy interest, serious invasion to reasonable expectation of privacy, undue burden, expense, intrusiveness of discovery against likelihood of discovery of admissible evidence, and some of the, I guess, factors are humiliation, annoyance, oppression, and embarrassment that might support a protective order. And then there's the discovery of electronically stored information, ESI, objections to production, and inadvertently produced ESI, like discovery of privileged material, promptly notify and require return or retraction, reasonable steps to retract if ESI has been shared, and there's a California ESI Act. Timing of discovery. Where do we pick up? Enforcing disclosure and discovery. So there's timing of discovery, pre-action discovery, beginning of discovery, completion of discovery. For timing of discovery, I've got ask the court to order pre-lawsuit discovery protection or before potential appeal by verification. Beginning of discovery, no initial disclosure in California, and completion of discovery, the cutoff date is 60 days before the trial, 15 days before the motion should be complete. Party may move to push back discovery cutoff date. You've got methods of discovery, oral deposition of witness, including a party witness, limits on depositions, which is 1 time, 7 hours, 30. I've written here 35 in total. That seems crazy to me. I think that's the number of interrogatories. Use of depositions at trial or hearing, errors and irregularities in depositions. So what I have is within 30 days, if no changes to transcript, it's approved as if it had been approved. As to notice, as to manner of taking, as to completion and return, that is all part of the errors and irregularities and depositions. So next page, deposition of witnesses on written questions. Objections as to form of written questions, interrogatories to the parties, 35 special interrogatory limit, unlimited form interrogatories, production and inspection of documents and things, tangible land ESI, tangible and ESI maybe, physical and mental examinations at controversy, order for examination, who may conduct the examination. The specialists are specifically named for physical and mental examination. Request for admission. The attorney can attend a medical examination, but not a mental examination. And experts, simultaneous exchange of expert list, additional details for certain experts must provide this. Require for writings and report, depose expert, no need to meet and confer unless incomplete or contain baseless objections. So that would be, I can kind of stop here because I just brought us to page 17, which is enforcing disclosure and discovery. So let me just read the beginning of this. So the deponent as a witness, 2, for any purpose if the court finds the deponent is dead or at a distance greater than 150 miles of the place of trial, or that the deponent is unable to testify because of age, sickness, or 3rd, for any purpose if the deponent is an adverse party. Enforcing disclosures and discovery. A, motion to compel and for sanctions. If a party fails to provide or provides incomplete disclosures or discovery, the other party may move to compel discovery or further discovery. If a party fails to comply with an order to provide discovery, the court may 1, order the matters to be treated as admitted, 2, prohibit the party from supporting or opposing designated claims or defenses, 3rd, strike pleading, stay or dismiss the action, or render default judgment, or 4, hold the delinquent party or witness in contempt. Discovery sanctions. The California discovery statutes authorize the court to impose actions for the failure to respond to discovery, making an unmeritorious objection to discovery, and disobeying a court order to provide discovery. And generally, initial misuse of the discovery process shall result in a monetary sanction unless the potentially sanctioned party acted with substantial justification or the sanction would be unjust. Subsequent instances of misuse could subject a party to escalating sanctions, including issue evidence and terminating sanctions, as well as more serious monetary sanctions. Pretrial conferences. The court must hold an initial case management conference within 180 days of the filing of the complaint. The purpose is similar to that of federal court. Some cases may be governed by California's Trial Court Delay Reduction Act, also known as Fast Track. And under Fast Track, the trial court assigns a time goal for disposition. To achieve the disposition goal, Fast Track places an obligation on the courts to actively manage civil cases, for example, imposing short deadlines on various procedures and requiring the court to hold pretrial case management conferences to access the progress of the case and to encourage diligence by the parties. The California State Court may impose sanctions against a party who fails to comply with fast track rules or court orders. Dispositive pretrial motions and procedures, involuntary dismissals, involuntary dismissal by the plaintiff. A California state court, either on motion by a party or on the court's own motion, may involuntarily dismiss an action without prejudice or failure to bring the matter to trial or to timely serve process. California statutes also authorize dismissal as a sanction in some circumstances. California diligent prosecution statutes and accompanying statewide rules of court apply to cases not subject to fast track. Voluntary dismissal by plaintiff. So those involuntary dismissals, fast track. California's Trial Court Delay Reduction Act. Got it. It's basically saying that your case management conference has got to be within 180 days, and they're going to set a time goal for disposition. And And for the voluntary dismissal by the plaintiff, in California state courts, a plaintiff generally may voluntarily dismiss her action with or without prejudice before the court makes a dispositive ruling on an issue of law or fact or the actual start of the trial. After commencement of trial, the plaintiff may dismiss the action only with prejudice unless the parties agree otherwise, or the court orders dismissal without prejudice based on showing of good cause. Page 18, costs and offer of judgment. So, glad this is just one paragraph because it sounded so complicated in my notes. In California, the prevailing party is entitled to recover costs which do not include fees of expert witnesses not ordered by the court. If the other party rejects the offer and the ultimate judgment is less favorable to him, he must pay the offering party's costs incurred after the offer was made, even if he was a prevailing party. The judge or arbiter also may award post-offer expert witness fees. Evidence of an unaccepted offer is not admissible except in a proceeding to determine costs. Summary judgment shall be granted if, from the pleadings, affidavits, and discovery materials on file, it appears that no genuine dispute of material facts exists and that the moving party is entitled to judgment as a matter of law. Time. In California state court, the party may bring a summary judgment motion after 60 days have elapsed since the general appearance of the party against whom the motion is brought, or at an earlier time that the court may direct upon a showing of good cause. The moving party must file and serve the motion at least 75 days before the hearing. So it's got the same definition: no genuine dispute of material fact exists, and that the moving party is entitled to judgment as a matter of law. The timing is at least 75 days before hearing. After 60 days have elapsed since the general appearance of the party against whom the motion is brought, at an earlier time, if there's good cause. And partial summary judgment, for example. Earlier time on good cause. Okay, so California allows for summary adjudication on less than a complete action, notwithstanding the parties' summary judgment motion. Parties may file a joint stipulation before filing a summary adjudication motion to resolve a legal issue or claim for damages that does not completely dispose of a cause of action, affirmative defense, or issue of duty in the case. The court will permit the motion to be filed if it concurs in the party's stipulation that the motion will further the interest of judicial economy by reducing trial time or by significantly increasing the likelihood of settlement. Support. The motion for summary judgment must be supported or opposed with admissible evidence in the form of affidavits, discovery, or admissions in pleadings. The moving party must also file and serve a separate statement on all material facts claimed to be undisputed, with the supporting evidence for each fact. Failure to provide the separate statement is ground for denial of the motion. Once the moving party has met its burden, the non-moving party must respond to the moving party's statement of facts by indicating which facts she believes are in dispute, along with supporting evidence for each fact. The failure to include such a response as grounds for granting the motion. Non-appealability. Denial of the motion for summary judgment usually is not appealable, except that a review by writ of mandamus is possible in California state court. So all of this sounds really similar to federal practice. Not at all different. So move on to the trial, jury trial. Peremptory challenge of a juror may not be exercised to exclude a juror on constitutionally impermissible reasons such as race or gender. Right to a jury trial in California state court. In California state courts, the right to a jury exists when the gist of the action is legal rather than equitable. If an action involves distinct legal and equitable issues, court usually first decides the equitable issues. Equity first rule following the jury's consideration of the legal, followed by, which is a distinct departure from federal practice. So equity first rule is what it's called. And what more is there to say? No jury trial exists if the legal issues are merely incidental to the equitable issues, equitable cleanup doctrine. The party must announce its demand for a jury trial at the time the case is set for trial or within 5 days after notice of settling. In addition to a timely demand, a party requesting a jury trial must make a timely deposit of jury fees and expenses. The right to a jury trial may be waived by oral or written consent. Okay, so you have to deposit money for jury fees and expenses. The right to a jury trial may be waived by oral or written consent, failing to deposit advance jury fees, or failing to make a timely demand for jury trial, but the court has discretion to relieve the party from the waiver. Parties of an existing action may elect to participate in the expedited jury trial, with restrictions on the length of the trial, the number of the jurors, and the number of peremptory challenges, and the ability to bring certain trial and post-trial motions and appeals. Jury instructions. Objections to giving or failing to give instructions must be made before the jury retires to consider the verdict. Jury deliberations. Jurors may take into the jury room only papers or exhibits and evidence and their own notes. A jury may not engage in experiments in the jury room. Jurors may not view property or places involved in the case except by court order. Communication with non-jurors regarding trial is prohibited. Jury verdicts. In California state court, a verdict may be rendered by 3/4 of the jury. The court may instruct the jury to decide on a general verdict in which the jury finds for the plaintiff or the defendant, or a special verdict in which the jury makes findings of facts and the court applies the law, or by general verdict with special interrogatories. So those 3 that are available in federal are available here. Erroneous verdicts. Inconsistent determinations are erroneous if they are irreconcilable. When a verdict shows on its face that the jury failed to follow the court's instructions, either the jury will be asked to redeliberate or a new trial will be ordered. A jury may completely change its verdict when deliberation is ordered. Juror misconduct. A new trial is appropriate if the juror gave false testimony during voir dire or concealed material facts relating to his qualifications to serve. The validity of a verdict may be challenged by admissible evidence of statements, including juror affidavits, and conduct that might have improperly influenced the verdict. Consolidation and separate trials. The court may consolidate actions then before it when the actions have a common question of law or fact, or order separate trials of any claim, cross-claim, counterclaim, or cross-complaint, or other issues when separation will foster judicial economy. Motion for non-suit and motion for directed verdict. In California state court, a defendant brings a non-suit after the plaintiff's presentation of the evidence or plaintiff's opening statements. The standard is the same as that for a directed verdict, whether the non-moving party has presented sufficient evidence as a matter of law to establish a prima facie case or defense when the plaintiff, why does this feel so new to me? Prima facie case or defense when the defendant moves for a directed verdict. In either case, the motion may be partial. For example, it may address only certain issues, leaving others to be tried. Any party may move for a directed verdict after the presentation of all evidence in the trial. Motion for judgment notwithstanding the verdict. is made after a jury returns a verdict. The standard is the same as is for non-suits and directed verdicts. The above, the timing is the same as that for a motion for new trial, which is 28 days. And in California state court, unlike in federal court, there is no requirement that a party bring a directed verdict motion before moving for an NOV. Well, that's nice and huge. That's a huge difference. Good. So I'm not going to mess that up. Motion for new trial. That would just be highly embarrassing. A motion for new trial must be filed no later than 15 days after the notice of entry of judgment in California state court. So then it's not really the same as federal now, is it? The timing is the same as a motion for a new trial, but it's 15 days after the notice of entry of judgment. That ain't right. The grounds include 1, misconduct on the part of the judge, adverse party or jury. 2, newly discovered evidence that moving party could not have by reasonable diligence discovered earlier. 3, unfair accident or surprise during trial. 4, excessive or inadequate damages. 5, insufficient evidence to justify the verdict, and the verdict is against the law. And 7, an error of law during the trial. If the motion is untimely, the court is without jurisdiction to consider it. So it's totally not 28 days after the verdict then. Anyway, remitter and additor. Remitter, whereby the plaintiff must accept either an amount that is less than the jury verdict or submit a new trial, is recognized in both federal and California state courts. Additor, whereby the defendant must either agree to pay an amount that is greater than the jury verdict or submit to a new trial, is available in California state courts only. Effective failure to move for a renewed judgment as a matter of law or for a new trial. Unlike in federal court, if a party fails to move for a JNOV or a new trial on the basis of insufficiency of the evidence, that party is not precluded from raising on appeal the question of evidentiary sufficiency to support either judgment as a matter of law or new trial. You already said that. Trial by the court. In a non-jury trial, once there is sufficient evidence to make dispositive findings, the judge may rule on an issue as a matter of law provided all parties have been heard. Alternatively, the judge may wait until all evidence is presented before ruling. In California, the court may issue a statement of decision. This is like the same thing right here. It's like the same thing. All right. Attack on the judgment at the trial court level. Relief from judgment or order. Clerical mistakes. A clerical error may be corrected at any time on motion of the court or any party. Other grounds for relief from judgment in California state courts. In California state court, a court may relieve a party from a judgment that was the result of mistake, inadvertent, surprise, or excusable neglect. Application must be made within a reasonable time, not to exceed 6 months. A court must set aside a judgment on a party's application made within 6 months of entry of judgment when it is accompanied by an affidavit of an attorney attesting to his mistake. Inadvertence, surprise, or neglect, even if inexcusable, a party may also move to set aside a void judgment. Never heard of that. What do we call that? That's Cool. For your exam, remember that in addition to different timing requirements, a California state court must set aside a judgment when the attorney submits an affidavit attesting to his mistake, inadvertent, surprise, or neglect, even inexcusable neglect. There is no similar federal court provision. I'd really like it if they had like a name for this, but that's fine. I don't get everything I want. Motion for reconsideration or renewal. Party can move for reconsideration of a prior court order, final or non-final, or she may renew a prior motion. However, as a jurisdictional requirement, the movement must show that there are new, previously unavailable facts, a change in law, or new circumstances that justify reconsideration or renewal. Final judgment and appellate review. We're on page 21 here, so there should only be like 2 more pages. So, relief may be granted. In California, when there is no answer, for example, default, answer stricken, as sanction, the plaintiff is entitled at most only to the relief requested in the complaint or the separate statement of damages or punitive damages. In any other unlimited civil case, the plaintiff is entitled to any relief consistent with the allegations of the complaint and the evidence admitted at trial. Thus, damages may exceed the plaintiff's demand and the injunction may be issued, although not requested. If in a limited case, relief is also restricted to the jurisdictional limitations of the court. Judgment on multiple claims or parties. In California State Court, if the trial court enters a judgment against one of several parties and the judgment leaves no further issue for resolution as to that party, it is considered a final judgment and may immediately be appealed. No express determination in contrast to federal procedure is required, but no appeal can be taken from a judgment entered on fewer than all causes of action. Here is yet another distinction between California state and federal practice that may be important to remember. In federal court, when a judge expressly enters an order that is final to fewer than all parties, the judge must expressly determine that the order may be appealed, whereas California state practice would allow the appeal. Okay. Time for appeals. Time limits for filing appeals are strictly applied, and the appellate court may not extend these times except in cases of public emergency. An untimely notice of appeal must be dismissed. The notice of appeal must be filed within 60 days after service and by the clerk, court, or party of the notice of entry of judgment, or 180 days after the entry of judgment if no notice was served. The timing for filing a notice of appeal, however, is extended when certain trial and post-trial motions have been filed. Review of orders and judgments. Generally, only final orders and judgments are reviewable. However, certain interlocutory orders are also reviewable. Interlocutory orders as of right. In California state court, a party may immediately appeal an order made after an appealable judgment, an order granting a motion to quash service of summons, or granting a motion based on forum nonconvenes, an order granting a new trial or denying a motion for judgment notwithstanding the verdict, an order granting or dissolving or refusing to grant or dissolve an injunction, and an interlocutory judgment or order directing payment of monetary sanctions in an amount exceeding $5,000. Okay, that's nice to know. I wish I had a list like that for federal rules of civil procedure. I feel like I had to learn that from like some crazy statute somewhere from like 1896. Collateral order rule in California state court, a party may immediately appeal a collateral order if I have to interpret some crazy old statute to figure out what stands for an interlocutory order. But a collateral order rule, likewise, same problem, federal civil procedure. In California state court, a party may immediately appeal a collateral order if the trial court renders a final order, and 2, on a matter that is collateral to the merits of the action, and in some courts, 3, the order directs the payment of money or performance of an act. And certification of class actions in California State Court. An order denying certification of an entire class may be immediately appealed. However, an order certifying a class or a partial class may not be immediately appealed. Review of non-appealable orders by writ. In exceptional cases, a final order may be circumvented through the appellate writs of mandamus, compelling a judge to act, and prohibition, prohibiting a judge from acting. Enforceability and stays pending appeal. Subject to numerous exceptions, enforcement of the trial court judgment in California is automatically stayed with the timely filing of a notice of appeal. However, enforcement of certain judgments, example for money, sale of real or personal property, appointment of a receiver, will be stayed only if the trial court so orders or if an undertaking is provided. And the California Appellate Court may also issue a stay. Civil jurisdiction of California Supreme Court. The California Constitution gives the California Supreme Court original jurisdiction in proceedings for extraordinary relief in the form of mandamus, certiorari, and prohibition. The California Supreme Court also has appellate jurisdiction over decisions of the California Court of Appeal. In addition, the Supreme Court has original jurisdiction to review certain administrative decisions and attorney and judicial disciplinary matters. Typically, the civil appellant files a petition for review with the California Supreme Court, which is granted only in approximately 5% of civil cases. In rare instances, the California Supreme Court may also grant review of its own motion after a court of appeal has rendered its decision, or may transfer to itself an appeal currently pending in the Court of Appeal. So here's the last section, 8 effects of judgment on future cases. We're going to go into claim preclusion, re judicata, followed by issue preclusion, collateral estoppel. For claim preclusion re judicata to apply, it must be shown that 1, the earlier judgment is valid, final, and on the merits. 2, the cases are brought by the same claimant against the same defendant. 3, the same cause of action or claim is involved in the later lawsuit. And 4, the cause of action was actually litigated or could have been litigated in the prior action. In California state courts, unlike the federal court, a judgment is not considered final until the conclusion of any possible appeals. Cause of action. The modern approach in defining what constitutes a cause of action is to require assertion of all claims arising under the same transaction or occurrence that is the subject matter of a claim asserted by the plaintiff. California state courts, however, have steadfastly adhered to the minority primary rights doctrine, under which a cause of action is defined as an invasion of a single primary right. Thus, for example, a plaintiff injured by a defendant in an accident may sue the defendant in one action for personal injury and in a separate action for property damages. Each injury would be considered an invasion of a different primary right to be free from harm. Issue preclusion, collateral estoppel. Issue preclusion is used to prevent a party in the instant action from relitigating an issue that was decided in a prior proceeding. The requirements for issue preclusion are: there must be a final judgment. The issue must have been actually litigated and determined in the prior proceeding. 3rd, the issue must be essential to the judgment of the prior proceeding, and the issue in the instant case must be identical to the issue determined in the prior proceeding. The party against whom issue preclusion is being used must have been a party or in privy of the party to the prior proceeding, because every party must have the opportunity to be heard at some point. And 6, when the issue preclusion is used non-mutually, i.e. by a party in the instant case who was not a party or in privity of the party in the prior proceeding, the court should consider the fairness to the party against whom issue preclusion is being used. California courts generally allow issue preclusion to be used defensively to avoid liability or offensively to establish an element of a claim. For your answer exam, remember that as a claim preclusion, California still applies the primary rights doctrine, which allows the plaintiffs to split property damage and personal injury cause of action without risking that the claim will be barred by claim preclusion. That said, be on the lookout for the possible application of issue preclusion. Even though a claim may not be barred by claim preclusion, issue preclusion may prevent it from being heard. For example, If a California state court came to a final judgment concluding the defendant was not negligent in a property damage case, issue preclusion may prevent the plaintiff from relating an issue of negligence in the subsequent personal injury claim, thereby effectively preventing the plaintiff from bringing a subsequent claim. The prior finding that the defendant was not negligent will prevent the plaintiff from proving a prima facie case of negligence. All right, that's it for civil procedure, and I'm just going to pause or before I come back and read another